Good morning. It's a great day here at Elville Associates, and welcome to our webinar series. Today's topic is what families need to know about planning for a loved one with special needs, presented by Elville Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville Associates, and I'll be your moderator this morning. We appreciate those that are coming back to see us for our webinar series and those that are here for the first time. We have several new attendees today, so welcome. You're at the right place for high-level legal education. We encourage your general questions today, as always, so please note them in the chat or the questions section on your screen, and we will pause periodically to address them. As always, your questions really add value and they help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me yesterday to take notes on them if you wish, and they're also available in the section marked handouts on your screen to download at this time. We also want to welcome our professionals on today's webinar. You may receive 1.5 continuing education hours for attending for most of you that are in attendance today. If you'd like to submit an ID number and your accreditation for me to provide a certificate of attendance or submit your attendance to the CFP Board of Standards, please send that information to me if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation. So please take just a couple minutes to fill out this very valuable information to us to offer us your feedback about the presentation. And we always read and value every comment. We have several new presentations coming up at the beginning of 2024 that are a direct result of your thoughts that you share in this survey. So here at Elville Associates, we always want to be a resource to your families and your planning needs, for your planning needs. And if you have planning needs to address old documents to review, or even another matter, so consider a consultation with Steve after today's presentation and use today's education as a jumping off point to get your planning started. Consultations are always an ideal way to get your specific questions answered, have Steve understand your individual situation, and create solutions and a path forward. And remember, one of my favorite quotes, as the best-selling author Tim Sanders said, "Education without application is merely entertainment." So Steve will talk about how to give you a path forward today as well. So we want you to enjoy yourselves, but also know how you can have a path forward today. So I'd like to give Steve and the firm a proper introduction before we get started. And you should be able to see my screen here. So Elville Associates, we were founded in 2010 in Columbia by Steve Elville. We have several different practice areas and services that we offer here at the firm, and they include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. And our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville Associates in several ways, through our planning processes with our clients, through educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have a CCP, as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville Associates. Just a bit about Steve. His work as an attorney for the past 20 years, 23 years to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses, their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time and 7th consecutive year in 2023. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts. which is our firm's charitable organization he founded in 2014. And I'm very fortunate to be the executive director of. So if you'd like to learn more about how we work to make a musical difference in the lives of children each day, please feel free to reach out to me when we have a little bit more time at a later time, and I'd be very happy to share our story with you. But for today, we have a very important topic to discuss about special needs planning, and we'd like to learn just a little bit about who we have with us today. So I'm going to share a very brief poll, and this is the hardest part of my day, is launching this poll. So if I can get through this, I'm in good shape. So the poll is, and I've successfully launched it, so everything is going great. To get to know our audience, please tell us what has brought you to today's webinar. And the first choice is, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited. Third, I'm a financial advisor here to learn to benefit my clients. Or lastly, I'm an interested family member here to gather information. So whatever has brought you here today, welcome. We're glad you're here. And we'll take just about 15 seconds here to see which brought you here. And happy holidays to you also. This is my favorite time of year. Thinking about what's important to us and being grateful. So everybody's quick on the button here this morning. Most everybody has cast their choice. We have 39% of people saying, I need to set up planning for a loved one with special needs. 28% say, I have planning in place, but it needs to be revisited. 6% say, I'm a financial advisor here to learn to benefit my clients. And another 28% say, I'm an interested family member here to gather information. Okay, well, whatever's brought you here today, welcome. Steve, I'm going to make you the presenter.
Hey, thank you, Jeff.
Button pop up in just a moment.
There it is.
Okay.
And thank you for letting me take over the screen, Jeff. And good morning, everyone. And I just welcome you on this Wednesday morning, this holiday season. It's hard to believe that a week ago we were getting ready for Thanksgiving. And so I hope you had a wonderful Thanksgiving holiday. And Jeff, you should be able to see my screen. Hopefully you see it.
I do. There you go.
Very good. And Jeff, how many years have we been doing webinars together?
Well, Steve, November 13th was my 10-year anniversary with the firm, which I'm very feel fortunate about. And I think we've been doing presentations pretty much since then.
Well, thank you, Jeff. And I just want to say a special thanks to Jeff for what he does to help me bring these presentations. And Jeff is a very high-level moderator, if you didn't know that. And he will know kind of intuitively and proactively when you may have questions. And so I thank him. I also thank you for being available and spending your time with us this morning on a very busy Wednesday morning, I'm sure, for you. And, you know, sometimes we forget just how much information that is packed into a webinar like this. And the kinds of information I'm going to share, which is so overwhelming for so many people. But I want to assure you that, first of all, this information is not rocket science. I want you to know that if you're here today and you're willing to spend the time and effort to make some notes on your phone, on your tablet, on a piece of paper, after this webinar, using this presentation to reference as a frame of reference, you can make great strides in your knowledge about special needs planning. So it is not something you can't learn. It's not something you can't overcome. So I want to just get that out of the way. The reason I say that is so many parents with loved ones with disabilities or relatives with loved ones with disabilities, they get very twisted around about this material. But it is actually very straightforward when you think about it, and when I hope you'll think about it later. And the reason I know that is because many people with loved ones with disabilities, they're so overwhelmed taking care of their loved one, dealing with public benefits. And we know that no matter how much education is out there, it is still very confusing for many families. So I just want you to know that this aspect is something that you can get your minds around. It is something that you can learn, and it's my extreme privilege to bring you this information. And Jeff and I and all of us at Elville and Associates, all of our attorneys and staff have been very blessed to work in the special needs planning community all these years. And so with that said, I'm going to share information with you this morning. Don't get overwhelmed by it. Take it one step at a time, and I promise you, you're well on your way to knowing 95% more than anyone you know about special needs planning. And we're going to go ahead and get started. And just know that obviously this is not meant to be legal advice. It can't be legal advice because we aren't in an attorney-client relationship, for those of you who are not the advisors on this webinar. But obviously we can enter into an attorney-client relationship in a consultation or other representation. So just know this is very informational, very high level, even though we are going to attempt to the best of our ability to answer your questions. Now, we're going to get started by talking about why the planning is necessary. So, we're going to enhance someone's life who has disabilities, obviously, to the maximum extent possible. And we know that some of you have loved ones that are maybe more higher functioning and can live more full lives rather than some that can't and are limited by their disabilities or their ability to be able to be independent. But whatever that person's potential is, that's what we're trying to reach in planning. But we're also trying to build a world of support. So you, as loved ones and parents and grandparents and other relatives, have this world of support already that you're providing your loved one by your love, by your presence, by your resources. And we also, many of us, are taking advantage of public benefits and the world of support that is offered by local and state government. But we also want to create a plan, and that's what special needs planning is, create another world of support, a world of support that will continue on after you are no longer here. And that is what I know many of you are concerned about. Housing, how much money will be available? How do we maximize public benefits in many cases, and in some cases, not so much? Everything is needs specific. So with that said, I want to make this webinar, as we have been trying to do recently, much more personal to you by taking a minute here. I'm going to take my timer on my phone, and I'm actually going to ask you to take 60 seconds here. I'm going to go ahead and start the timer. I want you to think about what has brought you here today. Jeff talked about in his survey the kinds of people that are on this webinar today. We have financial advisors, maybe some CPAs. We have people with existing planning. We have people with no planning yet for special needs planning. So knowing who you are, I'm going to ask you just to think about what is your perception? What is your intuition about the thing that you need to know most, or the things that you are weakest on that you would like to shore up about special needs planning and the world of special needs? Just take a few seconds to really think about that. What is it that I most need to get out of this webinar today, or in a follow-up meeting to learn more? We'll take about 15 or 20 more seconds on this. And by the way, before we go any further, all existing estate plans that contain special needs planning should be reviewed. So just know that we see lots of documents, and many of them are fairly weak in special needs planning. Sometimes we see some good ones. Many times we see very weak documents. So we need to update documents from time to time. To just know that if you're a person on this webinar that has an existing estate plan that contains special needs planning, those plans should be reviewed. So let's talk about the benefits of planning now. For many of you, some of these are going to be more important than others. Financial security, understanding and leveraging public benefits. You'll notice I put understanding in there because many of us do not understand means-tested benefits the way we should. And I will go one step further and say trustees of trusts many times do not really understand the kinds of benefits the beneficiary is receiving and they don't understand public benefits to, in conjunction with that. Not a good situation. We want to have lifetime management and management after your passing, depending on what your relation is to the loved one with disabilities. This could mean a planning team. Many of you have financial advisors and CPAs. Many of you do not. And many of you struggle with this. You struggle to find the appropriate financial planner, the appropriate trustees, the appropriate team members. We want to help you in that search. Appropriate housing is very important. Advocacy is important. Caregiving needs and understanding what those future needs will be. The entire extended family being able to gather around the person with disabilities and provide that solidified approach. Protection of the beneficiary from the things that are going on in the world today. Fraud, abuse, danger of all kinds. Trying to protect them as much as we can. And for some of you, it's going to be important to preserve assets, God forbid, after the passing of a loved one with disabilities, to be able to preserve assets for others who might survive the person with disabilities. So all of these are potential benefits. All of these are potential goals of yours. So again, I'm going to be redundant in some ways on this webinar, intentionally so. I mentioned advisors, so we may have to think about a lot about this right team of advisors. We want to think a lot about flexibility. We want to think a lot about advocacy, and we want to use special fiduciaries in many cases. A fiduciary is a person who has a high level of responsibility, like a trustee. Well, a trust protector is a special kind of fiduciary, so we want to cover that today. And I do apologize, I am recovering from an illness and I will have to stop from time to time. So let's talk about creating an effective plan. Well, first of all, we can't plan if we don't take time. So we have to have time to think. We have to have time to think about our choices. Excuse me. And this time to think is really a subtle thing. If we do not take the time to think, if we don't allow ourselves to be in a situation where we can receive counseling, then we have a situation where we will not be able to take in the information in our busy lives. We won't be able to make intentional choices, and we won't understand the contemporary choices that are available today. For example, where will our loved one live? I know for a fact that many of you are very, very concerned about this. Some of you are going to rely on public housing. Some of you are going to rely on group housing. Some of you are going to provide a place to live for your loved one privately. What level of care and who will provide that care? Will a guardian be necessary, or will we be able to utilize lesser restrictive alternatives? What are the players? Who are the players involved? What kind of lifestyle? Do I want a very liberal kind of approach to the planning, or do I want to take a very conservative approach? Am I building layers of protection? And do I really understand the process and the purpose of my planning? Because if I do, then I'm really going to be able to articulate a very, very nice plan. Now, let me stop right there. Already you can see that we're getting into the weeds here. And it is true that we do strive here at Elville and Associates to create customized estate plans, but I don't want that to be an obstacle to you. I want you to know that if you put some basics in place, you can have a very nice special needs plan for your loved one, even if you don't highly customize that plan, even though that is what we are known for, and that's what our educational approach is all about. But you do not have to have a highly customized plan, although you certainly could. Now, a memorandum of intent is one of these highly customized features. If you can imagine that there are millions of trusts out there, special needs trusts, general needs trusts, charitable trusts, everything you can imagine is out there, millions of trusts, and most of them don't have any personalization. They don't have a memorandum that sets forth your particular goals and desires. And in the world of special needs, I can argue that this is very important, and here's why. you can highly customize your special needs plan if for no other reason than to add this special needs memorandum of intent. And we are happy to help you start thinking through this by providing a template for you, even though you could create your own memorandum of intent at any time. And I'm happy to try to help you with that. But the idea here is we just don't know how many years in the future our trustees and family members that know our loved one with disabilities, we don't know how long they are going to live. We don't know how long our loved one is going to live. This memorandum of intent personalizes the special needs trust so that if there is a trustee in the future that is someone we can't anticipate, someone who does not know your loved one personally, this memorandum of intent will guide that person or persons about the particulars about your loved one. So just understand that this memorandum of intent is one of the first things you can do to personalize your special needs plan, even though it is not required. It is just something that is a highly customizable thing. So as we take the time to think, among all of the things we have to consider, we want to talk about expenses, anticipated living expenses, and we want to use the resources of our financial advisors. Whether you have a personal financial advisor or maybe a virtual financial advisor at one of the large wirehouses like Vanguard or Fidelity or Schwab, no matter what your situation is, there are resources available to you. And I would highly recommend that you form a planning team that includes a financial advisor that can help you think through these projections. And many of them have tremendous resources that they can make available to you. And I highly recommend that that's one of the first things you do. We can clearly set forth spreadsheets of all kinds. This is just an example. We can do all kinds of things through the resources of our financial advisors. And in that process, we also have to consider our loved one's potential incapacity, or whether they completely are incapacitated now for purposes of estate planning, meaning they either can or cannot sign powers of attorney and advance directives, and therefore they can avoid guardianship. Or we may conclude through counseling or through your own personal experience that your loved one does need a guardianship at age 18 or beyond. And this is a big decision for many of you. It's a counseling issue. Or many of you are familiar with supported decision making now, a year after it has passed in Maryland. And if you're not familiar with supported decision making, it is an alternative to guardianship, but it's also a way to enhance the quality of a person's life with disabilities, whether that person is young, whether that person is old, whether that person has intellectual disabilities or other disabilities. Jeff is happy, and I are happy to send you a copy of an article I wrote on supported decision making. And also we do another webinar on supported decision making. So remember, we are thinking about how are we dealing with our loved one's incapacity or potential incapacity, either through documents, a guardianship, or a combination of those things with a supported decision-making agreement. Now, let's talk about what I had brought up earlier, this issue of public benefits. It's crucial for you to know about them. Many of you do, and it's also crucial that your trustees understand. Let me stop right here and say that there's several books on the market about special needs planning. One of the ones I'm particularly fond of is How to Administer the California Special Needs Trust. So when we are talking about special needs planning, obviously all states have their approaches to special needs planning, but Kevin Urbash, U-R-B-A-T-S-C-H, U-R-B-A-T-S-C-H, Kevin Urbash wrote a book called How to Administer the California Special Needs Trust. And even though there's a California, Maryland, we're not really talking about California. We're just talking about the general information about how to understand special needs planning, including public benefits. So I highly recommend that book by Kevin Urbash, just to give you an idea of where some resources are, not only for you, but for your trustee.
Hey, Steve.
Hi, Jeff.
Hey there. Can we, before we dive into the public benefits, two things. First, you mentioned many resources, and I want to let everybody know that that's new and also that's been here, that I do send out a very comprehensive message afterwards that includes all the resources that Steve has mentioned and will be mentioning today. So you can expect that after the presentation. And we also have a question that is, since we are a Maryland-based firm, can you talk just a little bit about our ability and capacity to work with clients outside of the states, such as Virginia or Pennsylvania?
Well, thank you for that question, and I'll just answer that by saying none of our attorneys here at Elville and Associates are barred in Pennsylvania or Virginia, to my knowledge, but occasionally we do have clients that will come see us from these states, and we work as co-counsel in many cases with attorneys in other states, where we can be a part of the planning process as long as client is aware that we are co-counseling with another attorney in that state. Many times we are asked to review documents from attorneys that have drafted documents in other states. So we do this kind of multi-jurisdictional practice, but we cannot practice in those states per se if we are not barred in those states. But we can work in a co-counsel arrangement, generally speaking, with those types of residents in those states. Thank you for that question.
Okay, thank you, Steve.
Thank you, Jeff. Okay, so as we look at public benefits, I want you to kind of demystify this by thinking about public benefits at a glance with these three categories. On the left, we have means-tested benefits in the traditional sense. This is a person who is on SSI. Now, minors can be on SSI, but it's usually only in people that are in impoverished households. So for purposes of this illustration, let's think about people who are over 18. This person can be on SSI. They can receive $914 a month. It'll go up in 2024. But as a result of that, that person receives Medicaid or Maryland Medical Assistance on the local level. This is the quintessential public benefit. It's means tested, as many of you know, but this person cannot have more than $2,000 in their name. Now, I'm going to largely not talk about the right-hand column today because this is kind of beyond the scope of our discussion today, but just know that Section 8 and HUD benefits, those benefits have certain challenges when we are dealing with special needs trusts. If someone is living in HUD housing, there's certainly nothing wrong with that, but HUD has certain rules, and those rules were just recently updated, by the way, and it's a little bit challenging in the sense that anything that is distributed from a special needs trust can be deemed to be income to the person who lives in HUD housing. So I'm going to mainly focus today on this middle column and the left column. So let's go back to the SSI recipient. Many of you are aware that when you retire, meaning when you start your Social Security, if your child was disabled prior to age 22, your child will transition from SSI to SSDI, Social Security Disability. And that child will become what is called a disabled adult child, which we're going to see in other slides here. My point is that a person on SSI may not stay on SSI for their entire lives, even though I have seen 80-year-olds with SSI. The person on SSI whose parent retires and the person with disabilities was disabled prior to age 22, that person will transition to Social Security Disability, and they will receive 50% of the amount of the parent who retired, and at that parent's death, they will receive 75%. So this is something that many of you are not aware of. Some of you are. So that is kind of a great fact or a fun fact for you to know. Now, there are people who were not disabled prior to age 22, and they would not be disabled adult children in that sense. But look at this difference. When that person transitions from SSI to SSDI, they will get Medicare, of course, because they're on Social Security Disability, and they will also get Medicaid if they still are getting means-tested benefits. Now, there are people in this middle category who worked their own work record. They had a career of their own, and they have their own work record, and therefore they were not disabled adult children who will now get Social Security Disability based on their parents' work record, they will get disability based on their own work record. So these little nuances are very confusing, but this is just starting to get our minds around the idea of how this works. Now, SSI has tests. We're not going to go into those tests today, but just know this information is available to you. This definitions of disability are in here. We're not going to spend a lot of time on that. This is supplemental material for you. And the resource test, we talked about it being $2,000 for individuals. Note that a person who's on SSI, and remember that's the most restrictive, can only have $2,000 in their name or $3,000 for a couple. That person can own a house. Now, whether they should own a house is a separate issue, but they can own a house and that will not disqualify them from SSI. They can also own an automobile and of course burial plots and furniture and so forth. So SSI does not mean that a person could not own a house. Although many of you will not want your loved one to own their own house, you're going to want the supplemental needs trust or special needs trust to own that residence. And we talked about 2023 federal benefit is 914, and this can be reduced if we're not careful. So this is what we want our trustee to understand. We want to understand the concepts of unearned and earned income and how these can reduce SSI. This is for the person who is on SSI. And we want to be aware that if the trustee is not educated about these things, they could inadvertently cause this person to lose their SSI and therefore lose their Medicaid. So we have to be very careful about that. And that's why I'm recommending books like Kevin Urbash's book, so you can start to get your mind and your trustee start to get their mind around this. The in-kind supported maintenance and deemed income concept means that your loved one could lose a third. Now, this is the maximum amount they can lose as far as a reduction if you are providing food and shelter, for example. So remember, SSI is not for food and is for food and shelter, but if you're providing that, then Social Security will reduce your loved one's benefit by 1/3. And so we have to be intentional. Like if we're going to cause them to lose this 1/3, we want to be intentional about it. But most of you would not want to lose that 1/3, and therefore your loved one is going to pay rent or some other technique to make sure that they are not losing that 1/3. SSDI has certain tests. We will not spend a lot of time on that today, but this information is available to you. And also, I just want to make sure I didn't skip over. Yes, so the disabled adult child benefit, I almost skipped over that. I want you to be able to see this here in more detail and more written detail than what I described. So remember, if someone is disabled prior to age 22, they will transition someday from SSI to SSDI based on their parents' work record, and that's what I was referring to earlier. So I'm going to skip through a couple more slides here to get to the housing again. So Section 8 and HUD, there is such a thing as nice HUD housing. We just have to be aware that the HUD rules can be difficult to deal with when we are making distributions from a special needs trust. So if we can avoid our loved one living in HUD housing, my opinion is that is a good thing, but it's not always possible to avoid that. And the general idea about housing, again, is something that's one of the biggest concerns that you have. Should you plan on group homes and group housing? Should you plan on public housing in general? Should you plan to provide a home for your child if they are able to live independently or live with someone else or live in an arrangement where you yourself may own the group home? So this is part of the planning. It's part of the time to think discussion. And this whole notion is something that you can, really grasp onto, that a third-party supplemental needs trust, which we're going to talk about soon, that trust can own a house, and you can leave a house to that kind of trust in your basic estate planning. So let's get to the issues that many of you have really come today to this webinar to hear about, and that is the issue of special needs trusts. Jeff, I'm going to stop for just a second to see if we have any other questions.
Thanks, Steve. No questions as of now.
All right. And I apologize. I'm going to take about a 2-minute break and I will be right back to continue the discussion. I have a throat that's not cooperating here right now. I'll be right back.
Thanks for your patience, everybody. Steve's been battling sickness for a couple days, and very glad that he's here with us today. But no, he's not feeling his very best today. So thanks for hanging in there with us for a couple minutes. If you do have a question that's on your mind, be sure to pose that to Steve when he gets back, which he's here right here. So Steve, we did have a question that came up while you were gone for a moment.
Jeff.
I'll go ahead and pose it to you now. And that question is, how do I leave my home to my child with a disability? And then she goes on to say, that question assumes that life insurance will pay off the house.
Excellent question. I think that 9 times out of 10 in special needs planning, you're going to use your own will or your own revocable living trust, which remember is a substitute for a will. That is your basic estate planning vehicle. And you're going to leave that house through your estate or through your trust to a third-party supplemental needs trust, which we're getting ready to talk about right now. And that's a wonderful idea that in your will or trust, you can articulate that life insurance will pay off any existing mortgage. And that's a great strategy. And the house goes straight into the third-party trust where it is owned by the trust. Now, in some cases, which would be probably exceptional cases or rare cases, you might leave your home directly to your child and not leave it in a trust. But generally speaking, in special needs, you would leave it to the third-party supplemental needs trust.
Okay, very good. Thank you.
Thank you, Jeff. And thank you, everyone, for waiting for me to take a slight break there. So now let's get into this issue of special needs trust. And I would say this is where all the confusion arises. So I'm going to try to demystify that. Let's start with the first type of special needs trust. And we're going to actually call this a third-party trust. We might actually go further and call this a third-party supplemental needs trust. This is going to be the basics, the bread and butter of your estate plan. So now I'm talking about your estate plan. I'm not just talking about special needs planning for your loved one. I'm talking about your estate plan. So in your own will, just like this nice person just asked this question a minute ago, in your own will or in your own revocable trust, which is nothing more than a substitute for a will, you're going to create a special needs trust, or what I might call a third-party supplemental needs trust, right inside of those documents where it's embedded, it lives right in there. Or for many people, it's a better choice to have a standalone third-party supplemental needs trust. Why is this the bread and butter of estate planning for special needs? It's because this trust has no payback to the state of Maryland or any other state. So the third-party supplemental needs trust is the trust that you can establish. It's called a third-party trust because funds are coming from you or another relative straight to the trust and not to the person with disability. So it's a third-party trust. It's going from point A to point B. And because of that, And because the third-party trust is a discretionary trust under the Maryland Discretionary Trust Act, it avoids the claims of creditors. It is not an available resource for your loved one, meaning it does not disturb their public benefits. And at that person's death, many years from now, that trust will distribute to the survivors of whoever you say receives that money. So it is not a payback trust. It is the optimal vehicle for you to use in your planning. But this relates to your own estate planning. Where will your IRA go? Where will your life insurance go? Where will your house go if you're leaving a house? That's going to go to this third-party supplemental needs trust. Now, as you look at the second column and the third column, these trusts are called first-party trusts. Even though it doesn't say that, I want you to think in terms of third party. That's the main primary tool for you to use. The first party trust, which we're going to describe a little bit more later, this is a trust where a parent, grandparent, guardian, or court, or the disabled person can establish this first kind, which is called the D4A trust, under the United States Code. But this trust is not going to be used every day. This trust is for someone who receives an inheritance, or they are injured, God forbid, at birth, or they're injured in a car accident. This is a trust that might receive millions of dollars from a settlement, but the money is in the person with disability's own name. Because it's in their own name and it disturbs their public benefits, it disqualifies them, then the money can be placed in this first party trust and they can continue to receive public benefits or means tested benefits, but there is a payback. So the first party trust of the D4A kind is for someone who is under 65 years old. The first party trust, which is a pooled trust, which of the D4C type, is run by a nonprofit organization such as the Arc of Northern Virginia and so forth. So these are two different types of trusts. They are first party trusts when the person receives money in their own name that they should not have received, and the money should not be in their own name. So we want to use the first party trust where it is appropriate, but we want to avoid the first party trust if we can. Now, we can't always avoid the first party trust, and here's why. Sometimes a well-meaning relative will leave our loved one with disabilities money, and it's too late. The money is already in their name. It has to be placed in a first party trust. A good example of this is a well-meaning relative leaves a 15-year-old a $300,000 IRA, and that 15-year-old is on the autism spectrum, or is in the autism waiver, I should say. So that's just not going to work well, and that's where we need the first party trust. Another example where we really can't avoid this is, again, large settlements and that kind of thing from an accident or a birth injury. Another way that sometimes we have to use this, whether we want to or not, is when military veterans who have pensions and they have a special needs child under a certain law several years ago, that pension can be diverted or paid to a first party special needs trust on the death of the veteran. So that's a wonderful new law that was brought about several years ago, and we have to use the first party trust. But generally, for purposes of this webinar, I want you to be thinking in terms of a third party supplemental needs trust. And again, this is the best method of leaving assets for our loved one with disabilities. It is established by someone else other than the person with disabilities, and it is funded by someone else other than the person with disabilities. Now, I know no one on this webinar would do this, but there are people who will plan in ways that are not optimal. For example, let's look at this list. So outright inheritance. Some people will just, like I said, that well-meaning relative, they will leave money to the loved one with disabilities and cause a loss of SSI and a loss of means tested benefits. Clearly, this is something to worry about, and I'll give you an example. Many of you are going to try to do the right thing, and you will do the right thing. You will do the right kind of planning. But even though you are putting wonderful planning in place, you may be concerned about certain relatives of yours who may leave assets to your loved one with disabilities in non-optimal ways. So we want to coordinate with not only ourselves, but our immediate relatives who also may leave assets for the benefit of your loved one. So we don't want to leave outright inheritances causing a loss of benefits, obviously. Some people inadvertently will leave money to what we might call a non-qualifying trust. So some people might leave assets to a non-special needs trust, but they may think that they are doing special needs planning. So I've actually seen this phenomena many times where someone in good faith goes to an attorney, they create a trust, but that trust is really not a special needs trust or a supplemental needs trust, and it can cause the loss of benefits. So that's a sad and unfortunate situation. So that's why all existing documents need to be reviewed. And for those of you who implement supplemental needs trust or special needs trust planning, you want to keep those plans updated throughout the years. Another approach we see is, well, I'm just not going to leave any money for my loved one. I'm just going to leave it to someone else. I'm going to disinherit my loved one with disabilities. Well, that's not a good idea for several reasons, and let's look at that. Let's say that you took that approach and you left money to your children other than, or your brother or sister or your niece or nephew, someone that you think is going to take care of your loved one with disabilities, and you disinherit your loved one with disabilities. Well, now what if that person has creditors? This is a third person you left the money to in good faith that they were going to hold the money and use it for your loved one. Well, the creditors of that person obviously could get that money. What if they were divorcing, and all of a sudden they had made those assets available to their spouse, and now it was subject to separation and divorce? What if that person dies, God forbid, and leaves that money through their own estate plan to others who are not willing to share that money with your loved one or for the benefit of your loved one with disability? So we have to be very careful about this and how we leave assets and make sure that we are using that third-party trust appropriately. So again, third-party trust, the beneficiary did not create it. The trust does not hold any of the beneficiary's own money. It is the money from another person, and the beneficiary is not the trustee, and the beneficiary has no discretion over the trust. The third-party trust has no payback provisions to the state, and it can be revocable. So these are design features. These are things that people must take the time to think through. Today, we can create a revocable supplemental needs trust that can be flexible throughout your lifetime. Other people feel strongly that they want this trust to be irrevocable. So these are just a question of approach. And flexibility is very important. Drafting in flexibility, which we're going to be talking about. Now, trustee selection is arguably one of the most hot topics in today's world of estate planning. And we put on a webinar about how to choose or how to think about choosing trustees. But this in special needs could be a family member, it could be a professional, like a professional trustee, or it could be an attorney trustee, it could be a CPA trustee. So this is going to be a question of counseling. This is going to be a question of your particular circumstances. It also has to do with family relationships, the type of disability your loved one has, how independent or not independent they are, whether there are conflicts of interest about appointing family members, and so forth. So this whole process of trustee selection is huge and becoming bigger every day in the minds of our clients. So we strongly recommend, again, not to get overwhelmed with this, but to understand that through counseling and through time to think, really sitting and discussing and allowing epiphanies to happen. Well, okay, I understand what I'm trying to do now. I had to think through it. Give yourself permission to be able to think through. Some of you, this will be a straightforward. Some of you will not have any issues with this issue. Other people will struggle, and we're here to try to help you. Now, we talked about some of the custom design features, and I said from the beginning I didn't want you to get overwhelmed, but I do want you to know about them. And a trust advisory committee is one of those features. Many of you have loved ones with disabilities who are very, very straightforward as far as their care and their lives, and hopefully they're as happy as they can be and being productive as they can be. But some of you have loved ones with disabilities who have more serious issues. They could be psychological issues, mental health issues. Uh, there are going to be more challenges in some special needs plans. So a trust advisory committee provision might be something that's very helpful to allow the trustee not only to seek advice from professionals, but to actually be able to form a committee of people if they need to seek advice about the right approach for a loved one. A trust protector, in my opinion, is really not optional, even though it is optional. This is a special fiduciary that Maryland has recognized since 2014. And if your special needs trust that's existing or supplemental needs trust does not have a trust protector provision, I strongly recommend that you consider one. So a trust protector is a special fiduciary who has certain powers. So remember the idea that there are millions of trusts out there. Most of them have no flexibility measures. Most of them are written in stone. They're irrevocable, and they could be modified by new techniques in the law, but they don't have any basic flexibility. So a trust protector could amend a trust if the special needs laws change. A good example of this is the Secure Act, which has changed a couple of times in 2020. And people with disabilities, they have tremendous advantages under the Secure Act. So a change to the Secure Act could change how a special needs trust is approached in the drafting or need to be amended. Removal and replacement of trustees. Let's say that a trustee is not doing a good job. Let's say the trustee is not really present. A trustee doesn't understand public benefits and is causing harm to the person, or the trustee becomes ill. If there are no other trustees, the trust protector can remove and replace that trustee or provide a further trustee. So just understand this trust protector concept, I think, is a very good one. It just takes a little bit of time to get your mind around this, and you have to kind of have the right understanding of how to think through it. There are parents with loved ones with disabilities who will not want a trust protector, but I strongly recommend that you consider one. A trust protector could also compel an accounting. And remember, the whole idea is really just to provide flexibility. Now, if we were looking at a special needs trust, or what I might call a supplemental needs trust today, we would look at all of these features. You do not have to have all of them, but we recommend them. So we want to have good trustee selection. And as we go kind of counterclockwise, we want to have a trust protector unless there's a good reason or you're uncomfortable with having a trust protector. We want to provide for the ability of the trust to make payments to Maryland Able, make contributions. We want the trust to have advocacy provisions. We would love to see the trust have a memorandum of intent, even though that's a lot of work on your part. We talked about the trust advisory committee. We also talked about retirement plans and how loved ones with disabilities, most of them, will qualify for special treatment under the Secure Act, which means they are not limited by the 10-year rule that most people are going to be limited to, meaning they have to take all of the IRA assets out in 10 years. Rather, for special needs beneficiaries or people with chronic illnesses, they will be able to stretch out the distributions much longer throughout their lifetime. So we want the trust to be optimized for the Secure Act. And speaking of trustee duties again, we are just showing you these concentric circles. And Jeff has been very careful to try to find these pictures of these wonderful trustees who do many things, if not all of these things, perfectly. They are advocating for the person. They understand their interests. They're communicating with them. They understand public benefits. They're promoting quality of life. At the same time, they're accountable. They understand accounting. And if they can't do it themselves, they hire professionals to keep beneficiary details accounted for in the accounting. They comply with their statutory duties. And with regard to financial matters, they don't try to invest the trust assets themselves. They use appropriate financial advisors and professionals and they understand their fiduciary duty. So these are the kinds of trustee standards that you want to hold yourself or someone else to those standards as you look for trustees in your planning. So a supplemental needs trust can pay for many things, and it can be quite broad. So that is not something that is usually a worry. The question is how much discretion do we give someone who is the trustee? Should we force them to maximize government benefits, which is the traditional approach, or do we give them some more discretion? Well, yes, government would pay for this, but you can go ahead and pay for something else if you feel that what the government benefit is not sufficient. So that kind of flexibility could be built in, or it could be a very conservative trust. And the issue of how much to fund into the trust is really part of your own estate planning. So life insurance is a tool, your financial advisors are a tool, your retirement plan assets are a tool. The problem is, for most of us, is that we just don't know how much we're going to have when we pass away. So supplemental needs trust, special needs trust can be funded during life. And in a perfect world, everyone would fund the special needs trust during life. We would fund it on the basis that we just don't know how much we're going to have later. None of us really know that. So life insurance is a great funding tool for many people. On the other hand, most people who do special needs planning do not fund their trusts during life, but many do. And I'm seeing an increasing number of people who do fund them. So this is a counseling issue. It's a financial planning issue. And the question of how much is going to be driven by the needs of the person, how many children you have, whether you're leaving equal shares. All of these things are counseling issues that can be worked out, and you can come to terms with these things through the time to think. The first party trust that we talked about, this is a planning tool that we would rather not fund, generally speaking, because it is a payback trust to the state of Maryland. We talked about this, but this is a critical thing that is out there that we can use, and it gives parents and grandparents great peace of mind to know that even if we do planning on the third party trust, that if the child or loved one receives assets in their own name through an inheritance that they shouldn't have received, they were injured, they received a large settlement, whatever that case may be, it can be dealt with through a first party trust. And we're showing two basic types, the D4A type and the pooled trust. So again, injury awards, inheritances, someone who needs a first party trust, it is available and it is not difficult to get that implemented. So just know that this is not something that's mysterious. It is something that is done every day. The Attorney General of Maryland approves hundreds of these every month. So do not be dissuaded by the complexity of all of this. Yeah,
Hey there,
if we
Steve.
have any questions, I'll stop for just a second and then we'll wrap up.
Steve, you were just reading my mind. We talked over each other because I had the same thought. So we do have one question going back just a little bit to benefits. Question is, what if a child is not on SSI but is receiving Social Security retirement based on retired parents' income? Do they transition to SSDI, or do they stay where they are as long as the retired parent is living?
I apologize. I didn't get 100% of that question. It sounded like it said, Jeff, that if the person is not on SSI right now.
Yes, so if the child is not on SSI but is receiving Social Security retirement based on the retired parent's income, do they transition to SSDI, or do they stay where they are as long as the retired parent is living?
That's a great question. I think I understand it, and to the extent that I understand it, I would say this child is a disabled adult child. If they are a disabled adult child, that they were disabled prior to 22, they're on Social Security disability based on their parents' work record, then they will continue on. And as a matter of fact, after the parent's death, they will receive an additional amount. they'll receive 75% of the amount of the parent whose record they are receiving disability on. So if I understood that correctly, the answer is they will stay on that, and it will actually increase when the parent dies.
Okay, and next question we just received. Thank you, Laura. How can we minimize the risk of someone leaving assets directly to a beneficiary of a supplemental needs trust? If someone does leave assets directly to the beneficiary of a trust, what mitigation strategies are available?
Well, thank you for that. So this is one of the big stressors. So let's say someone, takes the time and makes the effort to come in and do special needs planning, and then they have to worry about relatives, whether the relatives are going to be cooperative. So I've seen two types of cases, as you can imagine. One is there are ancillary family members who are not really close, but they care about the child. Um, they are not willing to coordinate their planning with you. It's difficult to talk to them about money. It could be parents. It's difficult to talk to them about their estate planning because maybe they're very quiet about their estate planning. Um, they may or may not have a lawyer that's prepared their estate plan in recent years. So that's a challenging situation because you don't know what that person is going to do and they won't cooperate. On the other hand, there are wonderful families that say, okay, we're all on board, and you are doing third-party special needs planning for your child, and they want to be a part of the process. They want to make sure that they're changing their estate plan to be in coordination with you and your plan for the child, and also they are doing their beneficiary designations and making sure everything will flow properly. So that's the situation we want. So the best way to mitigate that is to try during the planning process to reach out to these ancillary family members and to try to get their cooperation. And if they have estate planning lawyers, if they're open and willing for your lawyer to communicate with their lawyer and make clear what needs to be done and share information. So that's really the issue, is sharing. Now, if you try your very best and you have to swallow hard and just put your planning in place and no one in the ancillary family is cooperating with you, then all you can do is all you can do. And then you have to be assured, you just have to have the assurance that if someone passes away and leaves your child money, and you definitely did not want that, you just have to have the understanding that it will not be the end of the world. It's not ideal, but it will not be the end of the world as long as your child is under 65, or if your child is over 65, we could use a pooled trust. That money that comes to your child will be dealt with. It will only temporarily disqualify them, and that money can be moved out of their name into a first party trust to make sure that they're back on their benefits. So that is really the only thing I can say, is that it's a stressor, but if it happens, there are ways to deal with it. So for example, just to give you one more assurance, the IRS only allows an IRA, an individual retirement account, to be in a trust under one circumstance without it triggering tax. So let's say someone in the family doesn't listen, they were negligent basically, and they left your child an IRA. Well, the good news about that is, the bad news is they received an IRA, they shouldn't have received it. The good news is that that IRA can be put into a first party special needs trust, and it can be there for the benefit of your child without triggering tax, putting that IRA in that trust. So the trust can actually own that IRA. So that's a very unique thing. So just trying to give you something optimistic about an otherwise unfortunate situation that could occur. But we want to try to plan for family and ancillary family planning all at once.
Okay, thank you, Steve.
Thank you, Jeff. And I'll start to wrap up now. I thank everybody's attention for your attention and for putting up with my cold today as I'm working through this process. So in thinking about establishing a special needs trust, what are the considerations? Well, this kind of unusual diagram shows that at Elville and Associates, we believe in a process. And as we go clockwise in this particular diagram, all we're really trying to show is that we're going to have several meetings to review several meetings to patiently let clients think through the process, think through their choices, think through these issues, just like we just discussed, and then eventually get to a signing, and also be able to make sure that assets are properly aligned. So assets could be coming straight to the special needs trust from IRAs, life insurance, or other assets, and then assets can be coming from wills or revocable trusts. And you'll see in the center there, we want to make sure that you have a planning team. And this planning team could not only include an attorney and financial advisor and CPA, but it could also include a life insurance professional. So process there is the biggest thing. If we engage in a process, we can engage in a learning experience that will actually educate you, educate your fiduciaries, educate the extended family members, and that's really the goal. And if you make that kind of extraordinary effort, that is all you can do. But it's not only all you can do, it is more than almost anyone you know would be able to do, because not only of your willingness, but because of the process. We mentioned early on about how to deal with your loved one's incapacity or potential incapacity, and we just always want to know that when we engage in the discussion about special needs planning, most parents, especially of younger children who are under 30, most parents are going to have issues and concerns about not only the special needs planning itself, but guardianship versus no guardianship, guardianship versus supported decision making, and powers of attorney and advance directives. This is a big topic of discussion. The waiver programs and making sure that we understand getting into the waiver programs before it's too late, understanding how all that works. SSI and SSDI, all of this is a discussion in special needs planning. The two types of guardianship, if guardianship is needed, is guardianship of the person and guardianship of the estate or property, as we call it. The thing to take away from this webinar is that in Maryland now, it is possible for someone to be under guardianship if that's appropriate, and also to have a supported decision maker. So traditionally, someone would go under guardianship and lose all of their legal rights per se, but now that same concept means that a person could be under guardianship and also theoretically not lose all of their legal rights because they are recognized as having preferences under a supported decision-making agreement. So if guardianship is the only alternative, it is possible under certain circumstances, and maybe it's appropriate, maybe it isn't, for the person to have a supported decision maker. And that will make many of you happy that that have either someone under guardianship now, or you're thinking about guardianship. And speaking of supported decision making, remember this is something that passed in Maryland and was put into law effective October 1st, 2022. And we will be glad to provide you further information about what this is. But in essence, supported decision making is a recognition of a person with disabilities that they have expanded rights. It's a recognition that the person can, no matter what their level of function is, and some of you will understand this and some of you won't. Some of you will be enthusiastic about this and some of you won't, and that's fine. Just understand that in theory, the law is that no matter what the level of disability a person has, this person can, the person with disabilities, can express their preferences no matter how much or how little, and the law recognizes their ability to do this. So in essence, supported decision making is basically this: I will make my own decisions to whatever extent possible, provided that I have the support to do so. Now, many of you support your loved ones and have been supporting them for years and will always support them, and you help them make these choices and preferences to the best of their ability, to your ability, and supported them and help them be independent already. But this is an additional recognition under the law that the law actually recognizes that this person has the right to express their preferences and to expect that those preferences will be honored. So I'll leave this to you to watch the webinar and also to read the article that I wrote or other articles about supported decision making. So we want you to create a memorandum of intent. We want you to create your own estate plan. We want you to establish a special supplemental needs trust or supplemental needs trust as part of that plan. We want you to have an advisory team. We want you to understand the Secure Act. We want your special needs trust to be optimized for those things. We want you to understand public benefits and your trustee to understand them. And we want you to generally be thinking about the future, despite all of the challenges you have in caring for your loved one and all of those things we're very familiar with that you're going through. We want you to start thinking about your advocates, and we want you to just really take today as the start of understanding what special needs planning is generally, and then you can kind of drill down into more of the details as you get more serious about reviewing your existing plans and also creating new ones. Now, when you move forward to have an existing plan reviewed or to start thinking about the design of your own special needs plan as it relates to your estate planning and your child or loved one, there is an estate planning consultation that we really need to do. And in that estate planning consultation, we're sitting in a high-tech conference room. We're using our tools. We're in an attorney-client relationship. There's nothing to fear. Many people are, rightly so, concerned about sitting down with someone and sharing a lot of personal information. But just remember that anytime you sit with an attorney and you share information in a consultative setting, you are in an attorney-client relationship and everything is confidential. We would like you to bring in your existing documents. So we'd like to review them if you have any, even if you don't have an appropriate special needs plan now, but you have old wills or old powers of attorney or an old revocable trust. We would like to see that and review it briefly. We don't charge generally to review existing estate plans. We would like you to complete a questionnaire. It is a lot of work to kind of get into this partnership process with an attorney and share information and give us information that we can use to advise you. So we would really appreciate it if you would do that. And we want to help you to form an advisory team. If you have a financial advisor that you're very happy with, then we want to know who that is. We would like to meet them. If you have a CPA you're happy with, we would like to know and meet them. If you don't have an advisory team, we'd like to help you form one. And we'd love to answer your questions when you come in. And today, many of you asked great questions, so I'd like to thank you for that. And of course, as we said from the beginning, our goal is education, counseling, not only of you, but your fiduciaries and trusted advisors, and also to give you the time to think about these things in a very, very daunting and busy world. So I want to thank everybody for your time and attention. Jeff, I'm going to turn it back to you, and I appreciate your patience as we worked through a lot of material. And Jeff, I think we actually ended on time. Thank you.
Thanks, Steve. It's funny how that works. Always a lot of information, but we always seem to end right about on time. So now would be a great time to get any final questions that you have in for Steve and have a few final words, and then we'll go ahead and wrap up right on time. So we do have one question here in the queue, and that question is, how does supported decision-making relate to the rep payee for Social Security?
That's a wonderful question. Well, it doesn't relate at all, although it seems like it would, in my opinion. The representative payee status, of course, is a substitute for guardianship. So guardianship of the property would be needed if your loved one had assets in their own name and they were under guardianship. But Social Security says if you're the representative payee, no guardianship is needed because that's a substitute. You're accounting to Social Security. You're handling that by way of that rep payee status. Now, what that means is that's a separate issue and apart and unto itself. Supported decision making has to do with what is the legal right of a person with disabilities to be able to express their own decisions, not be pigeonholed by old-fashioned notions of incapacity, and no matter what their level of function, and this is theoretical and practical, no matter what their level of function, they are recognized as having this right to express their preferences, their choices, so that their quality of life and their expanded rights can be respected. So that is kind of a different philosophical question versus the representative payee status is really just a function of accounting for money, which is a substitute for guardianship of the property. If I intuit your question a little bit further, I think what I'm hearing is, what is this relationship and would it be affected? And the answer is, if you were avoiding guardianship of the property by representative payee status, which you typically would, in other words, even if there was a guardianship of the guardianship of the property has nothing to do with the Social Security money that you are accounting for as representative payee. So no matter what's happening there with representative payee status, the person who has a supporting decision maker, a supported decision making agreement and a supporter, that person would not have control over their rep payee money. So that philosophical expansion of their rights would not go so far as to say they don't need a rep payee. So let's say a person with disabilities someday is able to function on their own and be able to handle their own money. Therefore, they would not need a rep payee. But if they have a rep payee and they have a legitimate reason for having one, their right to have a supported decision maker agreement and a supporter would not affect the representative payee status that you have or your management of the money.
Okay. And our next question is actually a webinar in and of itself. I will pose it though. Is the supported decision making a replacement for guardianship?
The answer is yes, it can be. And it was meant, when you read the article or you read the statute, you'll see the statute is not technical at all. And you could probably digest it in about 20 to 25 minutes. Supported decision making can be a substitute for guardianship. And several people, or many people who are under guardianship right now in Maryland, may have the guardianship terminated in favor of having a supported decision-making agreement. On the other hand, people that parents might say, well, this person is vulnerable, they need to be under guardianship. That parent might say, well, now that we have supported decision-making, I'm not going to pursue guardianship. I'm going to see if we can live in a world where my loved one with disabilities has expanded rights. We're willing to deal with their lives in going into the future without trying to take away their rights under guardianship. So the way I would like to think of this, and you'll see this in the supported decision-making webinar, is I like to say there is a continuum of capacity and incapacity, or a continuum of self-determination. And on this side of the continuum, we have advanced directives and powers of attorney. If a person has the mental capacity and can appreciate the nature of decision making, they can sign that. They now have agents. If they can't make their own decisions, there is an agent who will. Now, on the other side of this continuum is guardianship, which is the complete loss of rights. Over here, we have the retention of rights. Over here, we have the loss of rights. So here we have polar opposites. A person could be vulnerable and need a guardianship. They have vulnerabilities. They have clear needs for protection. That's what guardianship is for. In the middle is a happy medium called supported decision making. So a person could have powers of attorney and advanced directives because they are a higher functioning person who can appreciate these things, and they have the mental capacity, and they also can have a supporter. So what is the philosophy there? I will make my own decisions provided that I have enough support to do so, and my supporter will support me in my decisions and enhance my life and further my self-determination. If I can't make my own decisions because I'm incapacitated, My agents will make those decisions for me. That's that paradigm. Now over here, we have maybe someone who is in guardianship and or needs a guardianship. And the question is, even though that person is under guardianship, should they have a supported decision maker? And the law says that a person can choose to have a supporter and that the guardian cannot unreasonably say no. So that is a possibility in Maryland, whereas it's not a possibility in some other states. And then back to your original question, a person under guardianship could show by 2 physician statements that they no longer need a guardianship because they are not incapacitated, and they could live in a world where they have supporters and no longer need a guardianship. But this is a counseling issue, and for many people, in my experience, it comes down to how vulnerable is this person, and is it a good idea? Is it a good idea to remove the guardianship or even attempt the guardianship? I'll end that question by saying, or answer by saying, I believe right now across Maryland, these questions are being tested in court. These questions about someone under guardianship being able to appoint a supporter, even though the law clearly says that, we're still releasing, our society is still dealing with the old paradigm and the courts are trying to interpret the new law. And so we're going to have to see how this shakes out in the next few years.
Okay, thank you for that answer.
Thank you.
Next question, does a person on SSDI have a rep payee? And then she further says, I'm not the rep payee for my son, as Social Security said he doesn't need one, so I act as one without the title, but will start collecting my Social Security soon, so he will move over to SSDI.
Well, that's a great question. I think in a way you've answered your own question in my mind, which is Social Security, for whatever reason, does not deem your son to need a rep payee. Now, that could be because you've never asked to be one, or maybe you just wanted him to have control of his own Social Security disability. But it sounds like that you could be one because you're his mother and you're really the most high on the list of priority. And so if you ever deem that you should be the official rep payee, probably he sounds like he's a higher functioning person. So subject to his permission, you could go to Social Security and kind of take a small test and have them certify you as the rep payee. But I think right now somehow you're flying under the radar screen with no rep payee, and maybe that is a good thing, but you also probably could become one if you wanted to.
Okay, and last question for now. In doing a supplemental trust, do you also have to do financial and medical powers of attorney?
That's a great question. So part of good special needs planning, in my opinion, is, and that's one of the reasons why we mentioned it today. Let's say that you create a special needs or supplemental needs trust for your loved one as part of your own estate planning. Well, as part of your own estate planning, as the relative who's the support, who is the parent, let's say, or grandparent, you would always want to establish powers of attorney and advanced medical directives for yourself. One of the subtle things in special needs planning is the idea that your financial power of attorney is one of the most important things in special needs planning, because if you become disabled, your agent is going to take care of you, take care of your bills, pay your bills, but also take care of any person who is dependent on you. So your own financial power of attorney is hugely important, but it's a counterintuitive thing that most people don't realize. On the other hand, the child who you're doing supplemental needs planning for, a grandchild, if that person is higher functioning, good special needs planning will always be to address their capacity or incapacity issues, which is why we talked about that other concept earlier. So in a perfect world, the person with disabilities would sign powers of attorney and advanced directives themselves as a substitute for guardianship, assuming they do not need protection, they're not vulnerable, and you're not going to pursue guardianship of them. So that's part of good special needs planning. Whereas many other times in special needs planning, there is no ability to sign those kinds of documents. But if there is, the disabled person themselves should have those documents unless they are incapacitated and really not able to implement those.
Okay. And last question here, as a follow-up to the SSDI question, is it a requirement for SSDI to have a rep payee?
I'm not really sure about that. I don't think so. Only when I think about the idea that, let's say someone is disabled, they're receiving Social Security disability. Many people receive their own Social Security disability and do not need a rep payee. But someone who has disabilities and is not able to handle their own affairs, that person needs a rep payee. So my best answer on that is probably no. It's not required.
All right, very good. Well, thanks, Steve, and thanks to everybody for those great
Thank you.
questions. They really help a lot and help others that are here, I'm sure, have the same questions. So, Steve, thank you so much for being here today, and to all of our attendees. As we look ahead here to the end of the year, in just a minute, we have a few more webinars coming up to round out 2023, which I can't believe I'm saying. Next Wednesday at 10, Steve alluded to many different types of trusts. We'll be talking about some of those trusts, understanding the uses and purposes of irrevocable trusts, Wednesday at 10 o'clock. And then Friday on the 8th, achieving perfection for your planning, intentionalism in estate planning, one of our more popular presentations we offer a couple times a year. And that'll be offered by Steve at 10 o'clock. And I dare say virtually no other law firm would be talking about this type of high-level discussion that's so very important about being intentional in your estate planning. So make sure you tune in for that. And then to round out our webinar series for the year, December 12th at 10:30, we're going to be bringing back our wellness series, which I'm really thrilled about. We did 14 installments of it back in late 2021 into the end of 2022. Dr. Michelle Fritsch, a great friend of the firm and a nationally known speaker, thriving through the holidays, a celebration of gratitude. So one you don't want to miss. So we hope to see you there. And I'll be sending out a whole host of information for you related to this presentation, the video, the slides, all the resources that Steve alluded to that will be in the message I send out to you. So please open it and look through everything, and you can choose what you is most relevant to you. So, and just hold on to it as a resource for you for your future use. So we appreciate you being here today. Appreciate your interest in our webinar series and Elville and Associates. And if there's anything we can do for you, certainly let us know. That's what we're here for. So have a great day, and we'll see you again soon here on the Elville webinar series. Have a great day. And happy holidays to you. Thanks.